it is a great pleasure for me to be with you here in Lublin at the conference on European legal values. We meet in a moment when a discussion about the rule of law, constitutional accountability, and the limits of public power are not only theoretical questions, but it is a part of everyday public debate in many European states. My perspective today is a very specific one. I come from Poland, from a legal system which we have a special mechanism of constitutional accountability for the highest state official, the state tribunal, for example, and at the same time a very strong influence on criminal procedure on how this mechanism actually works in practice. This combination creates a model which is formally ambitious, but in practice raises serious questions about its effectiveness and about the quality of procedural guarantees. The title of my presentation, The New Perspective of Criminal Procedure and the Accountability of Constitutional Office Holders, in shortly, is therefore not an attempt to rewrite the whole system from zero. Rather, it is an invitation to look again at the existing model and to ask a simple question. I have two. What happens when we apply the logic and standards criminal procedure to the sphere of constitutional accountability? And second, where does this help to protect the rule of law, and where does it paradoxically block real responsibility? And with this in mind, I would like to start with a short diagnosis of the model we already have and then move to few concrete proposal and change. Okay, so ladies and gentlemen, a few months ago at the same forum, the first part, I presented the diagnosis of the Polish model of constitutional accountability. If you remember, I described the system as a hybrid, combining constitutional law in the one side and the other the instrument and guarantees of the criminal procedure. I identify what I call the immunity, very interesting evidence paradox. The prosecuting authority must demonstrate sufficient grounds to lift immunity, but cannot effectively collect evidence before immunity is lifted. It is the pure legal catch-22 from Joseph Haller book. Famous book and very interesting. And today I do not want to repeat this diagnosis. I want to ask more practical question: what should we do with it? How do we build a mechanism accountability that is effective but also fair? This is not only Polish question, trust me, that every constitutional democracy faces the same tension. If the system is too weak, it produces impunity. If the system too aggressive, it may produce political revenge. Both are dangerous, both are threats to rule of law. I would like to present 4 proposals to reform, but first one clarification about why the problem is so persistent. So why the system fails in practice? In the history of the Third Polish Republic, the State Tribunal has handed down a final conviction is, if I could remember, only one case concerning 2 persons. This is not only a statistic, it is the systemic signal. When we look at practice, we see 3 recurring scenarios. The first, the political pressure, for example. The state tribunal is announced or treated, but there is no real intention to reach a verdict. The procedure is used as a political rhetoric, not as a law. Second is procedural blockage. Proceedings begin but become stuck in a moment. The dynamics depend more on the balance of political power than on the quality of evidence. And third, very shortly, political impossibility. Even serious allegations never pass the required political thresholds. In all 3 scenarios, the same patterns appears. Accountability depends not only on facts and evidence, it depends on political power to activate the procedure. Procedure is not a technical detail, and procedure decides whether accountability is real or only symbolic. Okay, in this way, we have 2 dangers. With that in mind, before I turn to the proposals, one more point must be made clearly. If the system is too weak, it leads to impunity. If it is used too aggressively, it becomes a tool of instrumentalization and political revenge. Both paths are dangerous, both are threats to the rule of law, so the goal is not punishment at any costs. The goal is accountability that is real, legally grounded, evidentially justified, and non-partisan. In other words, accountability must protect the rule of law, not serve as a weapon in political struggle. And so we have a proposal 1. The first proposal by me is a concern the boundary between constitutional accountability and the criminal accountability. In a hybrid model, the same conduct may be seen in different ways. As a constitutional offense, as a crime, or as something is in a kind of gray zone between political, constitutional, and criminal responsibility. And that gray zone is dangerous in both directions. It may shield officials from real accountability, but it may also allow political actors to call something a crime simply because they disapprove of it. We need a clear criteria. A constitutional violation must be distinguished from a criminal offense on a basis of at least, for example, the degree of the social harm, the individual nature of the conduct, the legal interest violated, the existence of a specific victim or public harm, the form of guilt, and crucially, whether the conduct actually meets the statutory elements of a crime offense. A constitutional offense cannot be used as substitute for a crime when evidence is too weak, and a crime cannot be constructed artificially because political assessment is negative. We also need an institutional breach. If the body dealing with constitutional accountability established facts that may indicate a crime, there should be a duty to refer the matter to an independent prosecuting authority for the politicized assessment under criminal law. And proposal 2, rationalize immunity. The second proposal goes to the heart of the paradox I described last time. Immunities are necessary. Yes, of course, they protect public functions from pressure and abuse of criminal law. Without immunity, criminal procedure could easily become a political instrument, but immunity cannot become a mechanism of practical non-accountability. The key distinction is this: immunity should protect the office, not protect against the establishment of truth. In practical terms, this means that certain actions should be possible before immunity is lifted. For example, securing documents, analyzing files, interviewing witnesses, obtaining expert opinions, where with external judicial oversight, whatever individual rights are at stake, but without requiring immunity to be lifted first. Immunity should become full active at the moment the case turns into a case against, for example, a specific person, where charges are formally presented, or when a measure directly affecting the protected individual is applied. This model limits the immunity evidence paradox. It allows the necessary material to be collected. It allows a rational assessment of whether a request of lift immunity is justified. And it does not abolish immunity. It restores its proper function. And proposal 3, the third proposal concerns procedural guarantees. Procedural before the state tribunal are not classical criminal proceedings, but functionally they are very close to them. A specific person is accused, facts are established, guilt may be determined, sanctions may be applied, some of them penal or quasi-penal in nature. For this reason, procedural guarantees cannot be treated as a decorative elements. They must be hard limits of the system. For example, the presumption of innocence must apply, the right to defense must apply, the indubio pro reo principle must apply, equality of arms must apply. That follows from the Constitution and from Article 6 of European Convention on Human Rights too. Two elements of the current Polish model raise particular concerns. The first, in this way, the preparatory phase, first phase, is largely entrusted to the Constitutional Accountability Committee, a political body performing functions similar to pretrial proceedings without the external judicial oversight that applies to ordinary prosecuting authorities. And second, the State Tribunal acts as both first and second instance with no cassation review to the Supreme Court. This is difficult to reconcile with the seriousness of the case. A special case may require a special procedure, but the special procedure must not mean weaker guarantees. Proposal 4. It's very interesting but controversial. The fourth proposal is the most controversial, but perhaps the most interesting. I will refer to the Rome. To be exact, Juvenalis is one of the most outstanding Roman satirical poets. He was famous for his sharp, uncompromising works, the so-called satires, in which he brilliantly exposed the vicious hypocrisy and the moral decline of the elites and everyday life in ancient Rome. Let me return to Juvenal's question. Quis custodies ipsos custodes? Who guard the guardians? In a constitutional democracy, the answer cannot be only their political opponents. And it also cannot be only themselves. Another thinker, on the other hand, raised another argument. Tocqueville argued that citizen participation in judging is a school of democracy. It teaches citizen responsibility for the state and for the justice. In case concerning the highest state official, this idea has special importance. Constitutional accountability is not only a conflict between parties. It concerns the relationship between public power and citizens. I therefore propose concerning a civic element in the accountability model. There may be a stronger variant requiring constitutional amendment in which lay citizens participate the adjudicating panel. There may also be a more cautious variant, a civic lay council alongside the tribunal. Its role would be limited to assess select factual questions, to evaluate the social context of the case, to serve as a democratic buffer between party logic and the logic of justice. The civic element would not stand above law. Its aim, it is the opposite, to limit the monopoly of political parties over the decision whether the highest state officials should be held accountable. As Montesquieu put it, there is no liberty if the power of judging is not separate from legislative and executive powers. A civic element is precisely this separation. It places the judgment of the highest official beyond the reach of any single political power. State institutions must be designed to serve the political community, not only the current majority. And so for conclusions, let me now conclude with 4 broader lessons from the Polish experience. The first, hybrid models require a very clear definition of the relationship between constitutional and criminal accountability. Without this clarity, the system is open to both impunity and instrumentalization. The second, immunities must protect public office from abuse, but they cannot block the establishment of facts. Protection of the public function should not mean protection from the procedural truth. Third, where guilt is determined and sanctions are applied, the third rail standard must be full, non-partial. The special character of constitutional accountability does not justify weaker procedural guarantees. And the fourth, the civic element, deserves serious consideration, not because citizens should replace judges, no, but because accountability for abuse of the highest public power ultimately concerns the whole political community. And so the closing 3 voices. I would like to close with a simple triad. The Roman satirical poet Juvenal asks, who guard the guardians? De Tocqueville answers, citizens learn democracy through participation in justice. Montesquieu reminds us there is no liberty without separations of the power of judging. And my answer is, The guardian cannot be watched only by their political opponents. They must be watched by institutions that combine law, independent oversight, procedure guarantees, and civic legitimacy. Only then can constitutional accountability avoid two extremes: impunity on the one side and political revenge on the other. And only that can it truly serve the rule of law. Thank you
very much.